Hi, everyone. Welcome. I'm Janice Reicher, partner at Farrell, Braun & Martel and co-chair of our white-collar criminal defense and internal investigations practice group. Thanks so much for joining us today.
Good morning, everyone. As Shanti said, I'm Krase. I'm an associate at Farrell, Braun & Martel, and I practice in our white-collar defense and corporate investigations practice as well.
So today we're going to talk to you about the Foreign Corrupt Practices Act, or FCPA as it's known. This is an overview of our presentation. We're going to talk about some of the basics of the FCPA, some trends and developments that you should know about, and very importantly, what companies can do to minimize their FCPA risk. A discussion of the FCPA feels particularly timely right now, as anti-corruption enforcement is a major focus for the Biden administration. Many companies are taking a hard look at their anti-corruption policies and programs, or lack thereof, and whether those are adequate in this regulatory environment. In June of this year, President Biden issued a memorandum on establishing the fight against corruption as a core United States national security interest. And it starts off with the line that corruption corrodes public trust. It hobbles effective governance, distorts markets and equitable access to services, and overall undermines our national security. It's been estimated that acts of corruption sap between 2 and 5% of global gross domestic product. So the administration has announced that it seeks to increase resources and coordination among various federal agencies to detect and root out corruption. So it's great that you're all here today to learn about what your companies can do to aid in this goal. Let's take a quick poll. How familiar are you with the FCPA? Responses will be anonymous but displayed. Curious to know everyone's familiarity. Just take a few seconds and plug in your answer there. Very interesting. Okay, so let's see what our results are. Can you all see those there? Looks like we have 9% of our participants there are very familiar, 67% somewhat, and 24% not familiar at all. Okay, so it looks like we have a pretty mixed group here. Interesting to know as we're giving our presentation what everyone's aware this is.
We'll turn to a brief overview of what the FCPA is, which seems appropriate, especially since a lot of folks are somewhat familiar. We'll provide an overview, including some background and some best practices today. This is just a snippet of what the law provides, and we'll delve more into this as the day goes on, or the morning goes on, excuse me. So the FCPA was enacted in 1977, and it was enacted in response to revelations of widespread bribery of foreign officials by US companies. It was enacted to level the playing field and ensure honest business practices, which again now is reflected in the recent instructions from the Biden administration, as Janice spoke of. There are two main provisions. One is the anti-bribery provision, and two is the accounting provisions, which encompass the books and records. And the FCPA is enforced by two departments, the DOJ and the SEC.
So the first big provision here is the anti-bribery provision. And this is what people typically think about when they hear Foreign Corrupt Practices Act. It prohibits bribery of foreign government officials. Who is covered by this provision? Issuers. Any company, US or foreign, with securities registered in the US or that files certain reports with the SEC. Domestic concerns, US citizens, nationals, and residents, and any US entity or company organized under US law with its principal place of business in the US, so US companies. In addition, some might not know that individuals, directors, officers, employees, agents, shareholders of these issuers and domestic concerns, these companies, may also be liable personally, both civilly and criminally, if they personally engaged in FCPA misconduct. The FCPA anti-bribery provisions prohibit payments, offers, or promises made for the purpose of influencing acts of foreign officials in their official capacity, inducing foreign officials to do anything in violation of their lawful duties as officials, securing improper advantages for their companies, and inducing foreign officials to use influence with the foreign government to affect decisions of the government. Some examples of the kinds of corrupt payments made to government officials could be payments to obtain product approvals or authorizations to prevent the imposition of large taxes or fines, to get relief from government controls, resolve government disputes, to obtain contracts or business with governments, to increase efficiency in government processes such as customs. That's a huge area of risk, but not the only one. Customs and import duties, to gain project approvals, licenses, many ways in which payments made corruptly to foreign government officials can run afoul of the FCPA. In determining whether a payment is improper, we employ the business purpose test. Was the payment, offer, or promise made in order to assist in obtaining or retaining business or directing business to someone? The offer, promise, or payment must be made corruptly. What does that mean here? It means with the intent or desire to wrongfully influence the recipient. It has to be done willfully for defendants to be criminally liable, undertaken with a bad purpose. And Hiliary can discuss next what it means for things of value to be paid, offered, or promised.
So let's break it down a bit and discuss what it means to give something or anything of value. Some of these examples, cash or loans, might come to mind very quickly, and others might not, charitable payments. So before we delve a bit deeper into what some of these mean, I do want to note that travel, meals, and lodging are on this list as something of value. We'll discuss in a bit travel and lodging directly related to business can be permitted. So we see gifts on this list. I think it's appropriate to give an example from about 2013, a case brought by the SEC. There, foreign subsidiaries of US manufacturer Bank Security Systems spent $1.8 million on pleasure trips for senior officials of government-owned banks. They went to places such as Paris, New York, Disneyland. The subsidiaries also provided government bank officials with annual cash gifts, which ranged in value. Some were less than 100, some more than 600. The SEC found that these gifts and the travel were made to influence the bank's purchasing decisions. As a result, the US parent company paid over $48 million in fines for FCPA violations. Another example with regard to charitable payments or charitable donations, which I pointed out a second ago, a US pharmaceutical company's Polish subsidiary made over $75,000 in charitable contributions to a foundation. The foundation restored ancient castles in Poland. The foundation's president was also the director of a regional Polish health agency and had authority over the use of healthcare funds. The SEC found that the contributions were made to influence the foundation's president's power to direct business to the subsidiary. As a result, the parent company, the US parent company, paid a $500,000 civil penalty. Those are just some examples to give you a sense of what's going on, what the government's looking for when they say charitable payments can be corrupt. So we talked about what isn't allowed. What is allowed? Small gifts or token of esteem may be appropriate. In addition, payments for travel and lodging, as I referenced earlier, that are directly related to business and not intended to influence the official. Also, we'll discuss in a bit payments described as facilitating or expediting payments. And under defenses, we'll talk about that and how those are permitted in different scenarios.
I'd also add, so we talked about pretty tangible sort of payments and trips and lavish gifts, but it's not just monetary payments that qualify as things of value. For example, giving an internship to the son of a government official, that could be something of value that could run afoul of the FCPA, depending on the purpose and intent in giving that internship. If it's to influence the government official to take a certain action in favor of your company, to refrain from charging an excessive fine, something like that.
Thank you, Janice. It's really helpful. And that's a perfect example of personal favors. So we've used this term a lot, a government or foreign official. What does that mean? The FCPA prohibits bribery of foreign officials, those who work on behalf of the foreign government, department or agency of the foreign government. And this might not be obvious. Someone who works on behalf of a public organization like the UN or the World Bank, they would fall under this definition. Foreign political parties or political candidates as well. So let's do a quick poll. True or false, a company can be held liable for corrupt payments made by a third-party distributor. And again,
take a few seconds to.
The results will be displayed, but they'll be anonymous. We'll just give you one more second, and then I think we'll close the poll and discuss the results. Can everyone see the results now? Wonderful. So it looks like 96%, the majority of you answered true. True is the correct answer, although it's somewhat of a trick question. There's so many different factors to take into consideration here, and Janice will get into those in a minute. Some examples are, was the payment undertaken on behalf of the company? Was the company aware? Did the company bury their head in the sand to avoid actual knowledge? Those are some questions that the government will ask in looking at this. So with that, I'll turn it over to Janice to discuss payments to third parties.
I'm very encouraged that everyone, the vast majority of you recognize that third-party liability can be an issue here, because third parties pose the greatest FCPA risk to companies doing business abroad. Time and time again, we've seen enforcement actions involving subsidiaries, agents, distributors, those who are working on behalf of companies abroad, getting into trouble for FCPA bribery misconduct. Customs brokers, for example, historically have posed a higher risk for FCPA violations because of their high contact with foreign government officials and the variable amount of fines and fees associated with importing goods. So if you deal with third parties as part of your job, you should be mindful that if a company engages a third party, the company can be legally responsible for improper conduct that the third party undertakes on the company's behalf, if they have knowledge of that third party misconduct. And as I said, this could include conduct of agents, sales reps abroad, contractors, brokers, etc. What does knowledge mean for FCPA purposes? Knowledge of a corrupt payment to a foreign official can mean several things. There's actual knowledge or awareness. You know that that payment is being made on the company's behalf. That's a pretty obvious one. But there are also other kinds of knowledge that qualify. Firm belief that the corrupt payment is being made or is substantially certain to occur. High probability of these circumstances. For example, if a customs broker indicates to you, don't worry about those fees, we have ways to get around those, and then asks for additional funds as part of their services, in certain circumstances, that could form a firm belief that a corrupt payment would occur. Finally, there's the concept of willful blindness or deliberate ignorance. This is when you consciously disregard the corrupt payment. We'll see cases today and examples where companies straight up ignore whistleblower tips regarding corrupt payments. You can't just close your eyes to it and think it's okay because you don't actually know what's happening. You cannot be willfully blind and bury your head in the sand, as Hiliary said, when you see that there are red flags that corrupt payments are being made on the company's behalf. Speaking of red flags, there are many, many red flags that companies should be on the lookout for. We've listed a few here. Excessive commissions, if it looks like a company is asking for more money than they reasonably should be receiving to perform a service abroad for your company. Large discounts, vague terms of service. If, for example, a third-party contractor doesn't quite make clear what their services are, their contract, consulting fees, dealing with government acquisition, those kinds of things can be a red flag that the contractor is not doing things on the up and up. Close connections with foreign officials. If you know that you're dealing with a contractor or agent abroad who has very close government ties, family members or otherwise, that could be a red flag. Offshore bank accounts. If you're being asked to pay a contractor not in the country where they're doing their work, that could be a red flag as well. There is a recent case involving WPP advertising. This is the world's largest advertising group. And in September last month, the SEC announced an enforcement action against WPP. They had to pay $10.1 million in disgorgement, an $8 million penalty, and $1.1 million in prejudgment interest as part of an agreement with the SEC. They did not admit or deny the SEC's findings, but they agreed to cease and desist from violating anti-bribery, books and records, and internal accounting control provisions of the FCPA. So what happened in that case? In this case, there were descriptions of a Chinese subsidiary of WPP making unjustified payments to a vendor concerning a Chinese tax audit, and that resulted in $3.3 million in tax savings to the company. The order also describes a Brazilian subsidiary making improper payments to purported vendors for government contracts. And also in Peru, a subsidiary funneling funds through other WPP entities to disguise the source of funding for a 2013 political campaign in the country. The SEC detailed how WPP failed to ensure that their subsidiaries implemented their internal accounting controls and compliance policies and allowed those subsidiary heads in various countries to exercise too much autonomy. Complete lack of compliance in this case. They knew that there were inherent corruption and fraud risks, and they lacked the controls and management at their subsidiaries. They, in this case, also received 7 anonymous complaints regarding misconduct at their subsidiary in India and did not adequately or promptly respond to these warnings. So the internal controls were completely lacking here. And fortunately, the SEC considered WPP's remedial efforts and cooperation in reaching the agreement with the company. These remediation efforts included terminating senior executives who were involved in the misconduct, strengthening their global compliance and investigations policies, training employees, and enhancing their third-party engagement procedures. So this was a very recent, important example of where internal controls can really go awry if you don't have proper compliance functions in place.
We previewed this a bit before, but wanted to give you a sense of some exceptions and defenses. One is the local law defense, which might sound simple on the face, but it's a bit more nuanced. It must be lawful to act under written local law. So there was a recent case in the Southern District of New York where the defendant was accused of violating FCPA provisions. And the defendant argued for the local law defense to be a jury instruction for the jury. However, the court denied that because it's not enough for there to be an absence of a local law prohibiting the activity. It must be affirmatively allowed. The second exception or defense, reasonable and bona fide expenses, such as travel and lodging, extortion or duress, if you have to make payments to prevent physical harm. And then lastly, facilitating or expediting payments. And this might be ordinary payments to customs or to obtain licenses that everyone has to pay a certain amount and you pay that amount, and it's not intended to influence anyone's decision, the government's decision, and it's also not more than what everyone else is paying. And I do want to note before we move on that we're talking about exceptions and defenses to the FCPA. It's very important to look at local laws in the jurisdiction you're operating in, and even other laws in the United States to make sure you're not running afoul to those. Janice, did you want to add anything there?
Yeah, I just wanted to add that facilitating payments, that is one type of proper payment under the FCPA. But I would note that under other anti-corruption laws, like the UK Bribery Act, these are not carved out as permissible. So it's important to look at where you're operating, what laws apply, and create an anti-corruption policy that really addresses all the various regulatory regimes that you're working in. So next, we're going to talk about the FCPA's accounting provisions. Some people might be surprised to learn that the FCPA also covers financial misconduct that is unrelated to bribery of foreign officials. These are the accounting provisions. The accounting provisions require companies to maintain accurate books and records. These provisions are designed to identify any kinds of mischaracterizations, concealment, bribery, of showing expenses, liabilities not being properly reported. So the two types of provisions are accurate books and records on the one hand, and on the other hand, it's internal accounting controls. Who does this apply to? Issuers. Companies whose securities are registered with the SEC or who must file regular reports with the SEC, so not private companies. Although, obviously, it's important for all companies to maintain accurate books and records and internal controls, just good corporate governance. But these provisions specifically apply to issuers. So how do these two provisions of the FCPA work together, anti-bribery and the accounting? They will operate in tandem. Oftentimes, it's improper bribe payments and that kind of misconduct that is concealed through misclassification of expenses and accounting financial misconduct. What is covered? As I mentioned, it's not only about bribery-related violations. The accounting provisions also apply to non-bribery related misconduct. And it requires all public companies to provide accounting and books in reasonable detail. Now, when Congress specified reasonable detail, the purpose was to allow for reasonable detail that would satisfy prudent officials in the conduct of their own affairs. So perfection is not the standard here. It's about reasonable, prudent maintenance of books and records and that kind of detail. So I'll give a little example here. Also from September 2021, it's been a pretty active fall and late summer for enforcement. September 2021, the SEC charged the Kraft Heinz Company for accounting provision violations of the FCPA that were not related to any bribery. The SEC charged the Kraft Heinz Company with engaging in a long-running expense management scheme, resulting in the restatement of several years of financial reporting. They had to correct a total of $208 million in improperly recognized quote unquote cost savings arising out of nearly 300 transactions. This included charges against Kraft's former chief operating officer and former chief procurement officer for their misconduct individually related to the scheme. The charges include improper expense management for many years, including misleading transactions, bogus cost savings, and pervasive breakdown of accounting controls. Basically, they recognized unearned discounts from suppliers and maintained false and misleading supplier contracts, which improperly reduced the company's cost of goods sold and allegedly achieved so-called cost savings. And then they touted these to the market, and that was reported and hurt investors. This inflated their EBITDA. So the result, without admitting or denying any violation, they consented to cease and desist, paid a $62 million penalty. And interestingly here, the COO also had to cease and desist from future violations, paid disgorgement and a civil penalty. In addition to penalties, this chief procurement officer is also barred from serving as an officer or director of a public company for 5 years. So very, very grave consequences for both the company and for the individuals involved in the misconduct.
FCPA penalties and enforcement. We've talked about the sum, but just to dive in a bit deeper, companies and individuals can both be held liable. And what are the result of violations of the FCPA? Expensive and long investigations, criminal fines, civil penalties, both for the company and the individual, and potential imprisonment for the individual. So next, we'll look at some enforcement trends. We're seeing,
and for the companies too, I'll just add, Hillary, that the cost of not creating a robust anti-corruption compliance program could be very large for a company, even short of these issues here. Reputational damage is a huge issue. No one wants to be in the news for these kinds of violations, and FCPA investigations can be really expensive and long to go out and figure out what happened. How do we remedy this? How do we satisfy regulators that we are doing the right thing? So, in addition to criminal fine and penalties, and also the severe consequences for individuals, this could really be a huge distraction for a company trying to do their business and be good corporate actors.
so I think this is seen by looking at the graphic below. You see DOJ and SEC Resources, the continuing devotion of those resources to investigation and prosecution, more sophisticated investigation techniques, greater enforcement outside the US, and international cooperation. Again, as Janice said, and I think it's worth emphasizing, investigations can take years to complete. It's very drawn out. So although you see in 2021, 2020, the numbers are a bit lower, it's not indicative of a lack of resources or a lack of commitment to looking into and enforcing the FCPA. It takes a long time for these investigations to happen and for cases to come to fruition.
That's right. And I'd also note the increased number of individual prosecutions. This is a main policy goal of the Department of Justice, to not only charge corporations, but to find the individuals specifically who directed or condoned misconduct and hold them liable. There's a lot of pressure on prosecutors to find those individuals and make examples of them in many cases. So individual enforcement is something that we're keeping our eye on, and is very relevant at the moment.
Exactly what Janice is saying. This graph shows the increase in individual enforcement in gray, especially we see in 2019 DOJ, there were 25 claims against or enforcement against individuals. And we see that big emphasis on individual liability from the DOJ Justice Manual.
This is a pretty compelling chart here showing the increase in monetary sanctions from the period 2012 to 2021. We see the numbers just getting larger and larger. In October 2020, there was the largest penalty in FCPA history against Goldman Sachs. Goldman and its Malaysian subsidiary paid a $3.3 billion penalty. And this was as a result of $1.6 million in bribes paid by third parties to foreign officials for bond offering contracts, and 2 individuals were also charged. So $1.6 million in bribes, $3.3 billion in penalty. Huge news there. In addition, another example, Walmart, June 2019, charged by both the SEC and DOJ, paid more than $144 million to the SEC and $138 million to DOJ for third party, here we are again, third party intermediary payments to foreign government officials. And they also had an insufficient anti-corruption program. Such a huge company, and they, I'm sure, were well aware of the risks of doing business in these foreign jurisdictions, and still they had what the government considered to be an insufficient anti-corruption program. I'll also mention Beam Suntory, July 2018, October 2020, charged by the SEC and paid over $8 million to the SEC and $19 million to DOJ. And this was about improper payments made by their Indian subsidiary, improper controls as well. This chart shows total and average sanctions imposed on entity groups per year. In 2020, we see an average north of $400 million and total sanctions between 5 and 6 billion. So numbers keep going up. Along these lines, we have some trends and developments to share. So Stanford Law School has created some really great statistical compilations here showing Foreign Corrupt Practices Act statistics. You'll see here that the average investigation is 38 months. So these are investigations that take a lot of resources on the government side, as Hiliary said, and that's why some of the lower numbers for prosecutions in particular years might be the result of just investigations that are ongoing that have not come to completion yet. In addition, the average monthly cost for FCPA related investigations, 1.79 million. So these are expensive investigations, and the government is providing, Biden administration is providing greater resources to all these regulators to beef up their anti-corruption investigations and initiatives. You'll see here 74% of defendants settled with the DOJ, 93% of defendants settled with the SEC. So vast majority of defendants do settle. DOJ obviously is bringing criminal actions as well, so that might account for the lower settlement in that case. It's not just about money when you're dealing with a DOJ enforcement action versus SEC, just civil, obviously. So big picture, FCPA investigations are very costly and time consuming, and most defendants settle. This is an important heat map of improper payments. So when we're talking about FCPA risk and where we're targeting and zeroing in on for companies trying to evaluate their risk and how to adequately prepare their policies and compliance programs, we look at where they're doing business. Here you'll see location of improper payments from 2012 to 2021. China is in deep red. This is a place in the world where there's a lot of focus and we're detecting a lot of improper payments. Government officials, SEC, DOJ are zeroing in on actions in China by third parties, by agents doing business on behalf of US companies. There's a lot of activity there. You also see Brazil on the list. We've mentioned a case earlier, but WPP involving Brazil. This is also a hotspot for improper bribery payments. India, Mexico, Russia. Next on the list is Indonesia. That might not be as obvious as the other ones ahead of that, but it's important to think about where you're doing business and which areas of the world really pose greater risk than others, and to create your policies to take that into account. Here we have some industry trends. Oil and gas, very, very high risk area for FCPA. These involve lots of government contractors, high government contact, and potential for bribery. Healthcare is next on the list. Industrial goods, technology. Interesting to see where the real hotspots are in terms of industry and FCPA enforcement. And as I mentioned earlier, there are several places where we look to see what the government is doing to enforce FCPA, what their policies and priorities are. In the past year and a half, there have been a few guidances set forth by the government. There was the evaluation of corporate compliance programs update by the DOJ in June 2020. And that discussed how to function effectively with your compliance programs, what the government expects in your compliance programs, due diligence, documenting when things go wrong, why things are happening the way they are in terms of payments. The FCPA resource guide is sort of the Bible when it comes to FCPA best practices. The DOJ and SEC issued their second edition of this in July 2020, and it really gives you an insight into what these regulators are thinking about, what they find important, and there are also many helpful examples of the kinds of conduct that would be allowed or disallowed under the FCPA. There's also the FCPA opinion procedure release. This is a process by which companies can request an opinion by providing information to DOJ and say, based on these facts, can I do this? Is this payment going to be okay? Or am I going to be subject of an FCPA enforcement action? And they issued their first one of these since 2014 in August 2020. And this was an issue where multinational US companies sought an opinion about whether they could pay a foreign investment bank subsidiary for services rendered, and the government looked at the facts provided and said, given the payment here, the services offered, we wouldn't bring an action against the company.
And one additional thing to highlight has been included in, for instance, the resource guide by the DOJ and SEC. We've talked a lot about the importance of having compliance programs to avoid FCPA violations. But it's also important, and there are possible benefits if we do encounter a exposure area, and exposure arises, the government will look to whether you have a compliance program, how that's functioning, if you've taken remedial steps. So it can also be important from that angle as well.
Definitely. the first question is going to be, all right, something went wrong here, but what did the company do to set a tone of compliance? Is there an anti-corruption policy? Do you train people to abide by it? Those are some additional questions that you may hear if the government ever comes knocking at your door.
And this might be the slide everyone's been waiting for. How can companies, or what can companies do to minimize FCPA risk? So we only have a limited amount of time here, but hopefully we'll provide a good overview. There's more that we can delve into, of course. But first would be conducting a risk assessment, and this can be done through various means: data-driven analysis and review, document review, and fact gathering. So the data and the metrics is the new hot topic. It's been on the rise recently. And what does that mean? What data can companies look at to determine or identify risk areas? It could be anything from email systems, financial records, sales activity tracking databases such as Salesforce. This information, these data points can be gathered to identify and prioritize issues related to compliance. You can also look at other data, third-party management, integrity screenings, tender processes, sponsorships and donations, and this again helps to form the risk assessment. Going at it from another angle, you can look at potential personnel matters and issues that might arise, such as conflict of interest issues, completion rates of compliance programs, compliance conferences or workshops attended. So these can be helpful to aggregate the data and the information to identify and monitor. The monitoring is also key, not just identifying, but monitoring and developing as you go. In terms of document review, you can look at payment history, third-party contracts. I know we keep hammering home third party, but as Janice said, that's one of the greatest risks. And fact gathering, this can include interviewing company personnel and leaders in countries such as China, which poses one of the greatest risks, as we saw earlier. So it's important, I think it goes without saying, to be both proactive and preventative. Understanding country risk, looking at countries with high risk, China and Brazil, industries with high risk, oil and gas, healthcare, and focusing on different touch points such as third parties, or whether people in your company or third parties have contacts with government, and focusing on those areas. In conducting this, I think it's important to keep in mind the resource guide and the guidance from the DOJ and SEC. Is your program well designed? Is it adequately resourced and empowered to function effectively? And does it work in practice?
When you're creating a compliance program, it's definitely not a one-size-fits-all task. You have to look at where your particular company has greater risk, and depending on the size of business done in certain countries, the amount of government interaction, you're going to tailor that policy to be more strict or less strict, or have higher dollar amount thresholds, or whatever it is, in order to effectively detect and combat any improprieties. So it's important to conduct this kind of risk assessment and see where you are and what needs to be done to have an effective compliance program.
And that fits perfectly with some of the guidance that it has to be adequately resourced. So you have to know where to dedicate those resources to, and that goes hand in hand with looking at the risk assessment, which is different for each company. Also, what's important is continuing compliance. So training employees about what the FCPA is, what you have to comply with, whether it's also additional local laws like the UK bribery laws that Janice referenced earlier. Updating policies when you identify additional areas of risk, or when you review it and you need to remediate some issues. Janice referenced this when she was describing a case. It's important to have a confidential or whistleblower hotline so that people within your company can report different issues, and you can look into those and identify and minimize those risks. And again, third-party management. This is one of the critical areas. It's important to have a third-party policy to review and do due diligence on the third parties that you're working with, especially those that have contacts with the government. And We've also seen, and it's recommended to have agreements with third parties to ensure that they're aware of your anti-corruption policy or compliance policy, FCPA compliance policy, and that they're abiding by that, and they're agreeing to abide by that as well. And just at the bottom, bears repeating what prosecutors will consider well-designed, adequately resourced, and empowered to function effectively.
These are the 3 questions that you'll see repeated over and over again in guidance from SEC and DOJ. Well-designed, adequately resourced, and does it actually work? These are some of the hallmarks of an effective compliance program. It's important that from the very top of the company CEO to the very bottom of the company, everyone walks the talk, as they say. There needs to be a commitment from senior management and a clearly articulated policy that the company will not tolerate any kind of corruption. Codes of conduct and compliance policies and procedures are important for making this known to all the employees of the company. Oversight, autonomy, resources. It's not enough just to have the policy and keep it in a drawer or hand it to someone and not do anything else with it. There needs to be a real commitment and resources in enforcing that policy. Risk assessment we talked about earlier. Training, continuing advice. A lot of people who are working abroad on a company's behalf might not know about the FCPA. So training them and bringing this to their attention that certain kinds of payments and interactions need to be scrutinized more carefully is important. Incentives and disciplinary measures. If you learn that someone is engaging in FCPA misconduct, what do? There's everything up to termination, depending on the misconduct. And it's important that employees do have consequences when they engage in misconduct. Third-party due diligence of payments, confidential reporting and internal investigation. If you learn that someone has, for example, left a tip on the whistleblower hotline that improper payments are being made at a subsidiary in India, what do you do with that information? Conducting an internal investigation is the default answer to find out what happened, really making an effort to learn what happened and what the extent of the issue is, if there is an issue, and how to remediate that. Considering whether to self-report is another issue, a very tricky one that companies have to consider at certain points. Improving your policies, obviously, if you're merging or acquiring a company, doing your diligence and not just taking everything at face value, digging a little deeper and seeing if there are FCPA risks involved with acquiring that foreign company, for example. And as you mentioned, remediation of misconduct. It's important, as we've also mentioned, to look into the other applicable anti-corruption laws worldwide, UK Bribery Act, Canada's Corruption of Foreign Public Officials Act, Brazil's Clean Companies Act, China's criminal law and anti-unfair competition law. These are all very similar laws, but have their differences. So we would recommend talking to local counsel if you're doing a lot of business in one of these other jurisdictions. Okay, so we've given you a lot of information over the past hour. Let's put your knowledge to the test. Here we have a hypothetical about a company called TechCo. TechCo, a US company, seeks to start doing business in China, projecting that it will increase its sales by tens of millions by entering the Chinese market. TechCo hires a consultant to facilitate business in China and to help navigate customs. consultant is a local business person who has strong ties to political and government leaders in the country. What steps should company A, TechCo, consider before hiring a consultant? A, vet the consultant and his or her role in the transaction, including the relationship with government contacts. B, ensure that the contract spells out exactly what services consultant is providing. C, require the consultant to represent that she will abide by the FCPA. D, ensure that payments requested by the consultant have the proper supporting documentation before they're approved for payment. Or E, all of the above. Please take a moment. You guys are too good. Fantastic. Give a few more seconds.
And if you enjoy these hypotheticals, there are more in the resource guide for your perusal.
So everyone is right here. Those who picked E are particularly right. All of these are steps that you should take in considering hiring a consultant abroad under these facts. As we said earlier, looking at the relationship with government contacts, knowing what services the consultant is providing, letting them know that this company abides with the FCPA and anti-corruption laws, and they have to as well, and making sure that everything they do is properly documented and that you keep those records. It's very important. Well, this concludes our session.